That will be raised in the application if it ever comes back. For now, the matter is adjourned. The date is the 21st of May at 10.
Maybe you watch it.
It's your doctor.
Wait.
Afande.
You leave that place.
Afande jail kwa
Extend the
mkono.
other side.
Okay.
Extend the other side.
It's okay.
Extend the road. You leave the road. You extend the other side.
We shall never, never, never surrender. We shall never, never, never surrender. Never, never, never surrender. We shall never, never, never surrender. Never, never, never surrender. Never, never, never surrender. Never, never.
Uganda versus retired Dr. Kiza Besigye, Obedi, Lutale, Captain Dennis Ola.
Your Worship, with the permission of my senior colleague, the representation for the respondents, the first and second, Mr. Elia'S Lukwago, Mr. Apollo Katumba, Mr. Aaron Kiza, Mr. Bayan Turinawe, Mr. Ivan Buowe, Mr. Namakajo Derek Frederick, Mr. Kato Tumsime, Mr. Farouk Kamlegea, Mr. Silas Ogul, and Your Worship, I am Frederick Mpanga.
Your Worship, to bring this court to speed, this application came up last time, where prosecution made an application have been had in chambers. And this court duly granted it. Counsel for the respondents informed the court that they were pursuing an application for revision of that order to have the application had in chambers. And as a result, this court adjourned it for today for mention. But the purpose probably was to ensure that the application is had before, maybe the 30th. was a simple application. Revision, one of the simplest applications. But we have not, as prosecution, we have not been served that application. Maybe before I go into details, maybe we'll go out here from that fence, counsel for the respondent, so that we can make an informed prayer. So,
Your Worship, my colleague said we wish the application to be heard before the 30th, but he didn't disclose which application.
I think my senior colleague was busy writing while I was submitting. But I made the application for revision.
I wrote the application for revision clearly is a matter which would be heard by the High Court. And I wouldn't think, and I believe my colleague is aware, that this court does not determine the business of the High Court. Unless he wants to seek an order from this court to direct the High Court to fix the matter. Be that as it may, the application was filed. It is HCT-CR-CV-0017 of 2025. Your Worship, as my colleague should know, these days we file before or using ICNIS. When the filing is done, the registry at the receiving court has to validate the filing. It is then endorsed by the registrar. It is allocated to the judicial officer, who has to validate it, and who, in their discretion fixes it for hearing. The whole process is beyond the control of counsel. But it also wouldn't make sense to serve our colleague with a document which is not filed, which is not signed, and which is not fixed. That is why it has not been served. But it is in court, and once the administration or the administrative measures have been completed, and we have a date, they will see it on ICNIS, but we shall also serve a physical copy. That is here. Unfortunately, we don't carry ICNIS, but I see he has a phone, so he can check to confirm it is here.
Yes, Chief.
You know, just the application, that application which is going for, which this court had granted, be heard in the chambers. That application that is intended to facilitate an expeditious investigation in the main case. It is not enough for my senior colleague to just inform court how it was filed. We would want to know when was it filed. When was it filed? Yes, I appreciate the fact that he does not carry equities, but it's not also prima facie that prosecution was linked in to know that it was filed. As such, we need to have due diligence on the side of the defense to ensure that that application is had as fast as possible. Otherwise, it is frustrating the investigations. And apart from informing court that they filed the application, he has not gone ahead to even courteously inform court how far they are fast-tracking it. Because we have a limited period of time within which we're supposed to carry out our investigations. So I think counsel should be able to inform this court to avoid being in a state of, I don't know how I should say it, ambiguity. It's like we're in a certain ambiguity. It's the same thing which I submitted last time before my senior colleague Lukwago said I should apologize, and I said, you know, I said this is an act of arm twisting us. Because now we are there, we need to do investigations, but we are held. And again, from there they will say prosecution is not in any way doing this work, and yet we wanted to do this exercise expeditiously. If that application was done by then, by now we would be informing court the state in which we are. Because we need to have this matter committed to High Court as fast as possible. But we are being held. This one is intended to frustrate the investigations. It should be the defense that should be facilitating an expeditious process, but again, it is the contrary. This time around, Your Worship. This is not to castigate my senior colleagues, but just to say, you brief court, brief us on the state. We can't just be there to say, it was filed. When was it filed? You're given 30 days. We could be here when the matter was filed yesterday. And yet we were here last time on 4th. That is my prayer, Your Worship.
Your Worship, I understand that was a rejoinder. Do I respond?
I'm actually surprised that the mode of procedure today, because I think the state said he needed some clarification from the defense before he could go ahead and complete his submissions. So you have the right.
Your Worship, this is a criminal matter. And the application which Mr. Billy Bumbuka filed arises from a criminal trial. And I believe he's very much aware. While he's alleging that it should be the defense, Article 28, Sub-Article 2, Paragraph C, says that notwithstanding Clause 1 of this article, nothing in Clause 1 of this article, Article 28, Sub-Article 3, 3. Every person who is charged with a criminal offense shall be given adequate time and facilities for preparation of his defense. I want to assume that the step we took was in preparing the accused defense. So rather than castigating the defense, I think the first thing he should have done is to apologize that given the clear duties he must perform, he has done nothing whatsoever to avail us time and or facilities. For example, given that he is the state, he should have done his best to ensure that the record of proceedings of the day of the 4th were available on that day. Without his involvement, that record became available on the 16th of April. So much so that if we were to review the decision, and if we had to make reference to the record, we could only do so when it became available. I don't know that he's aware that it is available, despite his compliment. The second, Your Worship, the record which became available has 30 pages. The ruling was to have this matter come for mention. I do not find it anywhere for Mr. Billy Vumbuka, my dear colleague, to import the view that the court gave us 30 days. It is his creativity. But even if that is true, 30th of April is not 30 days from the 4th of April. So if we say that we have filed before the 30 days, I think he should be happy, himself having offered no support despite being commanded by the law to do so. Mr. Billy Vumbuka, as part of the state, is aware, Your Worship, that there have been changes at the High Court, including the movement of the chair of the head of the division and the appointment of due judges, namely the Honorable David Matovu, Mr. Justice David Matovu, as the head of division, the Honorable Mr. Justice Baguma from the civil division, Mr. Justice Matovu from Mukono High Court, and the Honorable Mr. Justice Baguma from the civil division to the criminal division. It cannot be that we came across that information on the street. It is only clear that we have been following up, and we know that the matter cannot be fixed until the new judges know the matters they are taking over. We also know that even the registrar His Worship Feston Senga, who is entrusted with fixing these matters, or the administrative work, was also changed. The only constant is the Honorable Lady Justice Comfort Kania, who is engaged with the matter now known as the Katanga trial. So all of those things, Your Worship, we have been pursuing without any assistance from Billy Vumbuka and the state as the law requires him to do so. But is here complaining? So if, and to the extent that from his counting 4th April to 30th April is 30 days, we have filed the application. Mr. Billy Bumuka is next to me, so you can see my file. This is the number. He can check and confirm that the application was filed. Your Worship, if it was filed just now, or yesterday, or on the 5th, the point is that the application was filed. We can only serve the application when the matter has been allocated to a trial judge, and when the trial judge has fixed the matter in their diary. Mr. Richard Billy Vumbuka, Chief State Attorney, complains about time. Your Worship, but for his frustrating acts of filing this application, to hear the matter in camera, would have finished on the 4th, and perhaps would have been proceeding. He is at liberty, if he has realized his error, to concede that we hear it now and cross-examine the person and proceed. But he cannot blame us for the consequence of his own action, unless he's saying that he was not aware of the consequences of his action. And we can only pardon him for that. So, Your Worship, we complied with the order. The application was filed. We have not served, because when we last checked, it has not been validated. It hasn't been endorsed by the registrar. The registrar has not forwarded it to a trial, has not allocated a trial judge, so it has not been fixed. But because he doesn't trust us, when we leave here, I will, at his expense, avail him a copy so that he can follow up on this number, confirm that I am telling the truth. That is the update we had. And that is all in case. Your Worship, my Minister of Our Sounds.
Yes, a part of one of the assertions made by Mr. Billy Bumuka, actually an accusation that we are attempting to frustrate investigation. That's a very serious one, which cannot go unchallenged, Your Worship. We pray that be pleased to expand that from the record if he wishes to withdraw it, because it's a very, very unfair accusation. Yes. I apologize because, Your Worship, if anything, it's the accused persons who are interested in the expeditious disposal of this matter. Because their liberties are curtailed. They have been in stated detention since the 16th of November last year. It's coming to 6 months. They have not been tried in any way. We are just embroiled in this ping pong, this gymnastics orchestrated by the state. We're not part of that. We're not responsible for that. For the record, Your Worship, the application before you was filed on 5th of March by the state. 5th March. If I may ask, why that delayed? What were they waiting for since the time the accused persons were kidnapped from Nairobi, illegally transferred to Uganda, their phones, their handsets confiscated because they have been in custody of the state since the 16th of November. The state has been in possession, in custody of the handsets. And they made no application whatsoever to access the data on those phones. Since 16th November, all through December, January, February, they wake up in March and file an application to access the data on these phones. And now they have the audacity of accusing us. Very, very unfair. So, Your Worship, we take exception to that very unfair accusation. Lastly, Your Worship, I think the question is very simple. It's not about when the application was filed, how fast it is being processed, when is it likely to be disposed of. The question is very simple. Is the application there or not? My land friend in Pang here submitted, what did the file number, application number, it is 17 of 2025. Unless the state has doubt about that, in which case the court can verify. But if that is a settled matter that the application is pending, then there is nothing to argue about. It's all about waiting for court to dispose it of. How long it takes, it's none of the business of this court. You can't set timelines. So we pray that Your Worship, without wasting any more time, you be pleased to have this matter adjourned until such a time when the application will be disposed of. We assure the court, the High Court is also mindful of the urgency of these matters. But I reiterate our prayer that Mr. Biluka should find it within his heart to withdraw the unfair accusations against us. We do so, pray, Your Worship.
Yes, President.
I will start with what my senior colleague Elia'S has submitted on. Your Worship, the reason why we submitted that this is one of frustrating investigation is because the defense was concealing vital information which should have been given to this honorable court. Because they had, when you conceal, it's like you're in one or the other, you don't mind. What I expected.
That is an application. That is
Your Worship, what I was responding to.
Can you respond to what he has said? Don't raise another.
Exactly.
Because, no.
Let me respond. The reason why, because when I respond, I have to talk about frustration because it came up in this. So should I just leave it, Your Worship, like that? Because we talked about it. I seek your permission. When you say I respond to what he has submitted, and in his submission you talked about frustration. But when I talk about frustration, you say I shouldn't say anything about it. Then what should I respond to?
concealing.
No, concealing. You talked about concealing, and that's what I'm talking about. So, can we stick to the frustration bit that you talked about without necessarily going into...
About concealing, I can't get another word.
Okay.
The reason why I submitted that defense is frustrating the investigation is because when my senior colleague in Panga was addressing court, he didn't find it necessary to inform this court on when the said application for revision was filed. And yet to us as a prosecution, it is vital. And why is it vital? It's because this matter was last in court on the 4th of April. And it was adjourned today, 30th of April, for mention. The reason for that was to ensure that court is updated on the status of that application. It ceases to be an update when my senior colleague uncourteously comes and informs this court how the application was filed. And the reason why we needed to know when it was filed is to understand whether the defense are taking that application seriously.
Your Worship, I wish to object.
No.
No, I'm objecting. Your Worship, the base of my objection is as follows. Having heard from both parties involved, it's true that the application for revision is not yet filed and therefore anticipatory at this point in time. The normal procedure, as defense has put it, is to file at High Court, which calls for the record. They have, however, indicated that time is of essence, and since the court made a ruling this very day, proceed with cross-examination. Should court continue with hearing of the said application, the rights of the accused to apply for revision will be trampled upon. Yes, this court can stay its own proceedings, but only upon proof of an application at High Court, which the High Court itself will call for the file, not in case of anticipatory matters to be filed. However, to enable the accused person to exercise their right, the court will adjourn this matter for mention to the 30th of April 2025 at 10 a.m. That is the ruling. Now, my objection is that Mr. Pilbubuka is reading too much in the ruling. It doesn't state that the defense tells us when the application was filed, when it will be heard, and how it is progressing. The adjournment was to allow the filing or the accused persons to exercise their right. They have done so. Perhaps, Your Worship, we can adjourn or stand over the matter so that counsel can access the registry on the ICMIS to verify this number.
No. Proceed.
I think this is the arrogance I'm talking about. You see, if you file, whether it is a physical filing, whether it is by ICMIS, it has a date. This is what we are talking about. We want to know when the application was filed. Maybe I can explain further for you to understand. Where a matter on the 4th of April 2025, my senior colleagues intimated to court how even that application was ready on that particular day. I remember. The anticipation, our anticipation was that it would be filed not far from that time. The date of filing speaks a lot to how and when that application is going to be fixed. And it also speaks to how they value that application. And if the application, for example, was filed yesterday, it demonstrates how the defense is intending to frustrate the investigations. Because we have been on record ever since we filed our application that that application was intended to enable or facilitate the investigations. So it is not a luxury, Your Worship, for this court to be informed on when that application was filed. My senior colleague shouldn't just be here and arrogantly inform the court about that. I think this is arrogance of the highest order. I know that this court never ordered for defense to file that application. It was out of their own evolution that they wanted to file that application for revision. And the prosecution cannot be held accountable for when the record of proceedings was available to them. Because even then, it is when you file that application, the High Court orders for that record. The court was just courteous enough to ensure that the record is available then. My brother should read the law very well. Anyway, regardless of that, Your Worship, given the circumstances, I would not object to the application to have that done. As my senior colleague suggested, that would be maybe it's what they should have said in the first instance without going into other things which are really. But we better have it as to be adjourned for a shorter period to ensure that this court is fully updated. Because as prosecution, we are interested in it. Because it has an element, it has a connection to the speed at which our investigations are going to run. That's all.
Heard from both parties, the defense has indicated to court that the application for revision at High Court has since been filed and is now awaiting allocation, endorsement, and fixing of the same. They have in that light prayed for an adjournment, which the state has objected to. So it's only proper to have this matter adjourned as we wait the decision from the High Court. The matter is therefore adjourned to the 21st of May for mention. The appeals are further remanded until then.
Thank you, Your Worship. Say 21st of May?
Yes, thank
Your Worship, we are now, just before court takes leave of the matter, we are now rising on a point of legality. Illegality. Your Worship, the principle is that an illegality, once brought to the attention of court, surpasses every other thing, including procedure. When my land friend, Mr. Elia'S Lukwago, raised the issue of the accused having been kidnapped in November and their gadgets taken by the state on the 14th of November, 16th, 2024. My land colleague in his able submission did not counter that. The assumption, which has not, the statement which has not been rebutted, is that the gadgets in subject, to the extent that they belong to the accused persons, have been in the possession of the state against the will of the owners since the 16th of November. In this application, drawn and filed by the DPP, which is represented by my colleague, Mr. Besigye, paragraph 4 states that the Uganda police took over the investigations of the case on the 11th of February 2025. And the deponent, Mr. Obedi, was one of the officers assigned to investigate the case. Paragraph 5. As part of the investigations, we received some items as exhibits in this case. A copy of the slip was appended and they were listed. They relate those to the accused persons, meaning that the state has been in possession of these gadgets per Mr. Obedi since the 11th of February. Your Worship, under the law, for which this application was brought. The law permits a party desirous of getting that information to keep it for a maximum of 72 hours. We have to pay my fee. Yes. 72 hours is 3 days, meaning that 11th, 12th, 13th, 14th. The only time the days have expanded.
So may I?
Yes.
I think this
You have to be raising a matter of illegality.
Yes, that will be raised in the application if it ever comes back. For now, the matter is adjourned. The date is the 21st of May at 10.
Maybe you simply